I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my hydrated co-host, Brett.
I am so hydrated, Alice. I have my bubbly water with me, my blueberry pomegranate, and a beer, which will probably dehydrate me, but that's fine because I got them both. It's working, they're going together. It's a Saturday night, so we got to celebrate, right?
This is just what I want to convey to everyone, that you are literally double fisting it while we're recording tonight with no script. I mean, we typically don't have scripts. Y'all know that. But this is a free-for-all double fisting kind of recording night. So we will see how this goes.
That's the thing. Hey, this is when you get older, this is how you celebrate on Saturday night. Some of you 20-year-olds are out there at the club while we're recording. But hey, this is where else would I rather be? Nowhere is the answer.
Nowhere. You know what I realized today? We were out with the kids and it started to storm, and my plan to exhaust them so they would go to sleep tonight was to take them to the pool. But you can't really take them to the pool when it's lightning and thundering. They frown upon that. And so I was thinking, oh my goodness, what if they don't go to sleep? And then I was like, well, if they don't go to sleep, what plans do I have tonight? And then I texted you to see if you wanted to record, because if I didn't have you to record with, I really would be doing nothing tonight. So you have given me a reason to do something on a Saturday night.
That's
I appreciate
awesome.
that.
That is maybe a sad statement about our lives, but that's fine. We're just going to move forward. And Alice is right. Tonight is going to be sort of a free-form thing. There's several topics that you guys have asked us to talk about, so we're just going to talk about them. We don't have as much of we don't have any structure, actually. Normally we have an outline. No outline. This is just us going.
I think there's no structure when you're double fisting it already, and it's not even that late tonight. I'm not going to lie.
It's true. But, it's Saturday. So, anyways, I don't want to bore everybody with what I did today, but it was a lot of sitting outside around water, possibly drinking.
Getting hydrated.
Getting hydrated, exactly.
You know what's awesome about Legal Briefs is that, honestly, the topics write themselves, because you guys are so good at writing in your questions, and you even label them for us. Hey, this is a shorter sort of question. Can you answer this on Legal Briefs? And we are going to do just that today, because two questions in particular kind of kept popping up, especially as we're going through the Casey Anthony series in our other podcast, The Prosecutors, which has been a wild ride, to say the least. So if you want to know more about Casey Anthony in the form of 7 episodes, go to our other podcast. But one thing that was really interesting that you guys asked us was, what exactly can or cannot the defense counsel say if there is no evidence to back it up? And this all sprung from Casey Anthony's attorney, Jose Baez, who theorized and argued a lot of things at trial that had no evidence to back it up.
Yeah, and it's an interesting question, because I just got to tell you, my initial thought was defense attorneys can say whatever they want, which is kind of true. We're going to talk a little bit about the limitations on that. But remember, the role of the defense attorney is to vigorously defend his client, to hold the government to their responsibility to prove the case, to sow reasonable doubt. And unlike the government, if you're a prosecutor, you have very strict requirements about what you can and can't say. I mean, the number of times I thought, man, it would be so nice to be a defense attorney, because defense attorneys, judges, they kind of let them get away with a lot because of what they are faced with. A lot of times people think the government has all these resources and the poor defense attorney is over there doing his best, and we're just going to kind of let him go. And in a lot of ways, that is true. And you got to think, why is that? Why aren't there more restrictions on what a defense attorney can do? Let's talk about first principles first. So you have a right in this country to an attorney, provided for you for free if you can't afford it. You have a right for effective counsel, for a counsel who is going to attack the government's case, that's going to try and present reasonable doubt. What you don't want, and what the courts are very leery of doing, is putting too many restrictions on what that defense counsel can do. And this is something judges struggle with, because it's not as if there are no limitations to what a defense attorney can say, but some judges, they're just really hesitant to limit a defense attorney in any way because they don't want to be seen as limiting the defense's ability to provide counsel, and the government is the one who's supposed to be proving everything. So to a real extent, judges and defense counsel believe that it's your job, prosecutor, to prove things and disprove things. So if I'm getting up there and I'm saying something and you don't think there's any evidence, tell the jury that. Like, hold me to it, right? And let's think about Jose Baez. Let's start with him and what he did, because it's really a good example of this. So Jose Baez, he gets up an opening statement. For those of you who don't know, Casey Anthony, if you're unfamiliar with the Casey Anthony case and you don't want to listen to our coverage, essentially Casey Anthony had a daughter who died. And the question was it an accident or was it murder? And Jose Baez stands up an opening statement and says, look, this is what happened to Kaylee, who's the daughter. She drowned in the pool. It was an accident. People freaked out and covered it up. And the reason Casey didn't say anything is because it was her father who covered it up, and he had been abusing her for many years. And so when he said lie, she lied. That's what she'd been doing her whole life. That's essentially his argument. And people said, if Jose Baez doesn't have any evidence of that, if he's really just kind of making up, how can he get up there and say it? And one question people asked was, is he perjuring himself? And the answer is no, because number one, he's not under oath. Number two, this is an opening statement. Number three, anything an attorney says is not evidence, which is often said by the court. So you might be asking yourself, what are the limitations? The limitations are essentially you have to have some sort of good faith basis that what you say in an opening statement, there will be or may be evidence to back it up. So, Alice, I don't know if you want to talk about motions in limine and what prosecutors can do to sort of push back on all this.
Yeah, absolutely. So a motion in limine is a procedural mechanism that basically comes before trial starts, and it's typically a filing. You can make them orally, but typically they are written filings that either party can file in order to set up what can and cannot be presented to the jury. So typically motions in limine are filed in order to keep some information out. So let me just give you an example. Maybe there's like a separate violent occurrence that has nothing to do with the case at hand, but the defendant, had some violent outburst and it was seen by a bunch of people at a party or something like that, but it has nothing to do with the actual occurrence. The defense may want to file a motion in limine to exclude any mention of or any presentation of evidence of a completely separate violent event because maybe the prosecution had included it in their discovery. Maybe they want to try to argue that because he was violent one time, he'd be violent a second time, the time that the jury is supposed to be determining. So they may try to keep that information out. You can have motions in limine for just about anything. The purpose of it is to try and get anything that may require argument settled before the case is presented to the jury so that what the jury hears is pretty streamlined. So you don't have to keep excusing the jury or having sidebars with the judge to determine issues of law.
As Alice said, you really want to do these before trial. And sometimes if you try and bring this stuff up when trial gets started, the judge will say, look, you should have filed something. We're not going to deal with this now. If you didn't want Mr. Baez bringing that up in opening statement, why didn't you file something? You didn't file anything. I'm going to let him do it. An example on the prosecution side, motion in limine, imagine, and I've filed these before, imagine that you have a suppression motion and the defense wants to argue that the defendant's rights were violated and that was the only reason the evidence was gathered, and the judge has ruled against them and said, no suppression issue, the evidence comes in. A lot of times you'll file a motion in limine to prevent the defense from bringing that up at trial. So you don't want the defense to be able to get up to the jury and say, the only reason we're here is because my defendant's rights were violated when this police officer you're going to hear from illegally searched his car, right? And you might say, well, he can make that argument because there's a good faith basis, but the judge has already made a legal decision that that's not true, that there is no suppression. And so he's not going to let the defendant argue that to the jury because he's already made the decision. So that's sort of an example of something you might try and prevent. In this case, the prosecution could have filed a motion in limine, which essentially could have said, because they knew what Jose Baez was going to argue ahead of time. They could have said something like, we want to prevent Baez from making these arguments about Casey Anthony's father unless he has evidence that he is going to present at trial to support it. The problem is Baez kind of has a trump card because what he can say to the judge is, look, Your Honor, if Casey testifies, she's going to testify to the fact that her father abused her. And she's going to testify to this. So I need to go ahead and get it out in opening statement so the jury's ready for it. And there's nothing the prosecution can do there because Casey has the right to testify and she has the right not to testify. And she has the right to decide that really at the last minute. I mean, it really happens after the prosecution puts on their case. The judge will say something like, is your client going to testify? Because if they're not going to, there's usually a colloquy where the judge will say, you know, you have the right to testify. You have an absolute right to testify. No one can take that away from you, et cetera, et cetera. And they'll sort of say in open court, I understand that. I have decided not to testify. So that's sort of a trump card because if she gets on the stand, she can say that. And so he gets to say it in opening statement. What's interesting about this is at closing, he was not allowed to talk about it because he hadn't put on any evidence throughout trial to support it. And so the prosecution made a motion and said, look, he can't bring it up because he hasn't developed any evidence. And that was sustained. So he wasn't allowed to talk about it in closing argument. A lot of times, this is sort of self-policing because if you're bringing up things in opening statement that you don't support with evidence, you're going to get hammered by the prosecution because of that. The jury's not going to like it because they're going to be upset that you promised something you didn't deliver. The Casey Anthony case is kind of unique in that the jury obviously did not punish Baez for that. And the prosecution, because it was a subject they really didn't want to get into, they were in a position where they didn't want to hammer them too much for not proving it because it would just remind the jury that, oh, there's this whole accident theory out there and this claim that the father was abusive. So it was a difficult situation, but ordinarily the way you police this is the prosecution sort of meeting its burden and showing that the defense is making arguments and making statements that it can't back up.
Yeah, absolutely. And so, I mean, it's really interesting here because even though Jose Baez could not bring it up in closing, obviously it had been put into the jurors' minds at the beginning already. So in some ways, the damage, quote unquote, has already been done. That seed has already been planted and that seed was stoked, even though there was no evidence throughout trial. And so this is what we mean by the trump card, though. And I've thought about it a lot when you guys asked this question. I was like, was there anything that limited him from talking about it in opening? Could the prosecution have done anything about it? And I really don't think so because the defendant has the absolute right to or not to testify, and she does not have to tell the judge or the other side anytime at all. I mean, she doesn't have to tell them as she's walking up there. And typically that's what happens in our cases. We do not know if the defense is going to put on the defendant until they either rest or the person takes the stand. And honestly, in every case, even if the defense knew, I don't think they would tell us because they'd rather keeping it hanging out there because it can really affect your strategy whether the defendant testifies or not. So I've never had a trial where they definitively told me they will not testify. It's usually this like rote song and dance where like, I don't know, my client really wants to take the stand to prove that they're innocent, but I keep advising them as their wise counsel not to do so. I hear that from every single defense attorney, and it might be true. That may actually be the case, but I do think because she can leave open the question, Casey Anthony can leave open the question as to whether she will testify, and we don't know what she's going to say. There's no report, right? She hasn't testified in court before. She hasn't testified before a grand jury, so there's no recorded witness statement from her that would go against the fact that she may testify her father abused her.
And I think a lot of you guys just assume that defense attorneys always think their clients are guilty or always think they're lying to them. But a lot of times, you know, they believe them. I can't say that Jose Baez doesn't believe Casey, that her father abused her. Like, I can't say that Jose Baez walked in and Casey said, I murdered my daughter and dumped her in the woods, help me. And Jose said, well, we're going to make up a story that your father abused you and it was an accident. I think most likely Casey was never as honest with him as that. And Baez thought it's perfectly plausible that that was happening. Casey may or may not have told him that that was happening. We talked about this good faith basis. One of the reasons it's so dangerous if your client testifies is it throws a lot of wrenches into what you can do. Because while you as the attorney can say a lot of things, one thing you can't do is suborn perjury, which means if your client told you, I did it. This is how I did it. Here's all the details. And then you put them on the stand and they start to perjure themselves and lie about what they've done. You're in a very difficult position as an attorney because you can't actually allow them to sit up there and lie. Now, you can't say, oh my goodness, jury, she's lying, right? And you can't tell the judge she's lying. And so a lot of times, if a client insists on getting on the stand and lying, what a lawyer will do is request to withdraw. And that can get really sticky because you've got a lawyer who's telling a judge, I need to withdraw from this case. I can't continue to represent my client. I can't tell you why. And I mean, that's awkward, right? So putting her on the stand makes it much more difficult for them for a lot of different reasons, but also just because once she's on the stand, then what you know about the reality of the situation becomes much stickier for you. And there's a lot of times where defense attorneys are having to walk a very fine line. Another thing that happens is, we talked about that suppression thing and how you can't bring in suppression if you lose. Well, what if you win? So if you win a suppression issue and you keep a piece of evidence out, but the case is going to continue to go forward because the prosecution still believes they have enough evidence to succeed. If you're the defense attorney, you have to be very careful about what you say. If you put your client on the stand, what they say, because things that are suppressed for constitutional reasons can all of a sudden come in for things like rebuttal. So if, for instance, your client admitted it in a non-Mirandized statement, yeah, I did it. And then your attorney gets up in opening statement and says something like, and the police had no reason to think he did this. Well, he's just opened the door because he's just made a claim that's rebutted by this piece of evidence that had been suppressed. And then all of a sudden, the thing that had been suppressed can come in to show that indeed the police did have a reason to believe he did it. So it's just all very complicated with defense attorneys and what they can do and what they can't do. But I think bottom line, there's broad discretion when you're a defense attorney because you really are in a position of judges not wanting to tie your hands, and the prosecution is really the one that's supposed to be proving things.
Yeah, that's right. And, I haven't done criminal defense work, and I do know it's a tough balancing act that you have to do. I don't claim to know how difficult this is, but because of all the kind of tightrope walks we were talking about, in my experience, having practiced in courts across the country, generally the defense gets away with a lot more than I think they probably even are allowed under the rules, but it's because of this kind of acknowledgement of the burden being on the government to prove the case, and that the defense kind of has fewer tools at their disposal, so to speak. I think about this all the time when we interview witnesses. When we interview witnesses, we have said this before, we as attorneys never talk to fact witnesses alone. We always have an agent, law enforcement, with us so that we do not end up being the fact witness on the stand. We have kind of a buffer, someone else who does testify on the stand under oath. And that just kind of allows us to do our job as the lawyer and keep us separate from being a fact witness and knowing the facts of the case and having to testify to court. Defense counsel are in a different position because they have attorney-client privilege with their client, and they're having to speak with their client, who is obviously their main source of information about the facts of the case, alone all the time. And so when you are faced in that situation that Brett just described, where you know that the defendant is going to perjure themselves and what to do, in a lot of ways, you're all alone in trying to figure that out and how to thread that needle. It's a position that prosecutors are just not in because we are never the only ones speaking to our fact witnesses. And so that's actually one of my nightmare scenarios.
Yeah, some defense attorneys have weighed in on this and made similar points to what we've said, that you just have to represent your client and it's up to the prosecution to figure it out. But I would love to hear from some defense attorneys if you have thoughts on this about sort of the ethical limitations to what a defense attorney can say. But I really feel like most defense attorneys just feel like as long as there's a good faith basis to make the argument, they can make the argument and the prosecution has to figure it out. It's funny, Alice and I had a case once where the guy was pro se, so he's defending himself, and he really wanted to make this one argument that he just thought was absolutely critical to his defense, and we had filed a motion in limine, and the judge said you can't make it, and he kept trying to make it, And at one point, he had some documents, and one of the documents was the argument that he was trying to make. So he had this stack of documents, and he kind of slipped it in there, and then he tried to admit the stack of documents into evidence. And we flipped through, and there was a document that he can't use. I mean, there was that kind of stuff, which...
It was so funny. I mean, it was like every hour he would literally like slip something, be like, hey, I'm going to admit this. And like it would be turned upside down, flipped over, and then there would be like a totally innocuous document on top of it. And he's like, you don't need to look through it. We're like, no, we need to look through it.
We're going to look through that. But yeah. So... Anyway, it can be kind of crazy when you get into this stuff, but it's fun. Well, look, I hope that answered some of your questions about that. There's no hard and fast rules, but to the extent you think Jose Baez, I think he was absolutely within his rights to make this claim. And I'm sure what happened is he sat down with Casey and he said something like, you know, if we said that your father abused you, is that something we could say? You know, like he probably just kind of led her to where she was like, oh, yeah, my father, he totally abused me my whole life. Right.
And that's a really good point, too, Brett. You know, as the prosecution, I'm pointing out ways where it makes it a lot harder to be defense counsel. As prosecution, we can subpoena people to talk to us. Right. And they can choose not to cooperate. But like we do have investigative tools. And for the most part, when we go to trial, prosecution has spoken to more of the witnesses that are part of the case than the defense, because the defense can also reach out to the same witnesses. But the witnesses don't have to talk to the defense. We never instruct them not to talk to the defense, but you can just imagine a lot of people, you know, for whatever reason, they may not trust speaking to the defense because they think they're talking directly to the defendant, whereas for the government, they're speaking to the government. There are at least maybe some protections there. And the defense attorney has to basically come up with what the story is without being able to talk to all the witnesses, right? And the only person, like we said, giving them ideas is going to be their client, the defendant. And so oftentimes the defense will kind of fish around with their client and be like, well, I mean, was it an accident? Like, did you oversleep? Can you even remember something like that? Do you remember things like that? Like, is it a memory issue? Were you too far away? Do you need glasses typically? There's no way that could have been you. You'll see them kind of fishing around for alternate explanations and seeing what sticks with their client. And then if something seems plausible, they may try to start going down that path. But it's really honestly a tough position they're in to figure out what the story should be, sometimes without any help from their client.
And you got to remember, I mean, once again, it's the prosecution's job to prove a case, period. And to the extent they're bringing up other possibilities, it's the prosecution's job to show that the evidence shows that that's not what happened. I think the prosecution did that in the Casey Anthony case. The jury did not. But, like, I don't want to offend defense attorneys, but I think defense attorneys kind of get a bum rap a lot of time because they really are sort of upholding a constitutional principle. You really need to hold the prosecutors to their job. Like, they need to prove it. And if there's possibilities out there that might even be in the jury's mind, there's nothing wrong with bringing those up. And look, this was a delicate situation in Casey Anthony because of the specific accusations, but at the end of the day, there was no proof of any of them. And the jury should have taken that into account. That should have affected the way the jury thought about it. It shouldn't have worked. It did, and that's life, and that's the subject of a 7-episode discussion that we're not going to rehash here. But at the end of the day, it's the prosecution's job to prove the case. It's the defense's job to defend their client, and they are going to get a lot of leeway because of that. And yes, there are ways the prosecution, if the defense is going to bring in a theory for which they have no proof and they cannot provide any proof, then yes, a motion in limine would be appropriate there. And if when we say they shouldn't be able to bring this up because they don't have any proof of it and it will confuse the jury. I mean, that's the thing. It's kind of Rule 403. Is this going to confuse the jury? You don't have any proof of it. You're going to bring up this outlandish claim. It's going to confuse the jury. Then it's incumbent on them to say, no, judge, for these reasons, this is at least plausible. We're going to put on a witness who's going to talk about how it's plausible. You see that sometimes when they just want to blame somebody else. Well, maybe it was the milkman, right? And you can't just do that. You can't just throw out some random person who might have done it if you literally have no reason to believe that they are responsible for it. So alternative theories to the crime are very important for defense, but they have to at least have some basis. And so, like I said, I know this is a little confusing, but just know that to the extent there are limitations on the defense, it basically has to be they're going to say something that just there is nothing to support it. And there won't be anything. And that was the difference here with Casey Anthony. If Casey Anthony had testified, she could have supported what Jose Baez said in his opening statement. And that's why I think, regardless of what the prosecution did, that was coming in. So that was the first thing we want to talk about. The second thing we want to talk about, most of you have been following the InfoWars Alex Jones defamation case, where he at various times said that the Sandy Hook parents whose kids were killed in a mass shooting are actually crisis actors who didn't have kids, and there was no massacre and there was no mass shooting, and this was all a false flag operation to justify the end of the Second Amendment. That's essentially what he said. And so those parents sued him for defamation. That's a pretty clear case of defamation. And in fact, Alex Jones didn't even contest liability. He didn't even contest liability. Everybody admitted, yeah, this was defamation. Oops. It was just all about damages, whether or not there should be damages in this case. And last week, right before this case closed up, the plaintiff's attorney was cross-examining Alex Jones, who was on the stand. And he said something which sort of shocked everyone and sort of set Twitter. He said something like, "Did you know that your defense attorney accidentally sent me the entire contents of your phone and did nothing to get it back? And so now I have the entire contents of your phone." And Alex Jones looked very surprised by this. And so a lot of you asked, what does that even mean? What's going on here? Is that even possible? And so we thought we would talk a little bit about discovery and how discovery works and how privilege works and what should have happened and how it was really weird that it didn't happen, but just sort of the basics of what was going on there.
Yeah. So there's a lot there. So let's rewind all of this first, because I think the confusion comes from what the attorney said and what he alleged in his question, right? That this was a mistaken turnover of evidence, that Alex Jones's attorney never should have turned it over. It was a mistake, but he forgot to claw it back somehow. So now he gets a gotcha in court. So let's rewind all of this. First, discovery. In any sort of civil lawsuit, and this is a civil, not a criminal lawsuit, there are discovery obligations on both sides. And there's usually a discovery deadline. Discovery just means information that you get to ask the other side about that's going to be relevant to the claims at issue. So they come in lots of forms. They come in the form of interrogatories, requests for admission, for documents, for depositions, all these sorts of things you probably heard about that make up the evidence. And each side is trying to ask for the evidence they think is going to prove their case. And as long as it's relevant, narrowly tailored, not, fishing expedition, not scorched earth, not trying to just abuse the other side to make them hurt in terms of having to turn over a ton of documents that are irrelevant, it's discoverable. And so in this case, discovery was going to be due well before trial. Now, in real life, is there late discovery? Like you've missed your deadline, you found something late, or even worse, you were hiding something and it comes out late? Yes, that happens, and we hear about it. It's when it goes wrong that we hear about it in these documentaries and on TV. So in this case, the emails and text messages, basically the entire contents of Alex Jones's phone, were apparently turned over, and they had information about him texting about Sandy Hook, right? And that was information that had been requested in discovery. And based just on the questions, I haven't seen the contents of the phone, but based on the information the attorney was actually using to impeach or cross-examine Alex Jones, it was relevant. And apparently it had been asked for in discovery. And Alex Jones's side had responded, there are none. There are no emails about this. We've given you all the text messages. There are none. So their response was, we've already turned it over. But clearly there was additional information that fell under what was discoverable.
And I just got to say, so there's no ineffective assistance of counsel in a civil case. It's not like he can appeal because he was found there were damages, $40 million, I think all told, that he's going to have to pay. So it's not like he can appeal and say, my lawyers were ineffective, give me a new trial. Now, he could seek to have some damages himself because of malpractice on the part of his lawyers. And I'll be interested to see if he does that, because there are a few things that happened here that really are weird. Number one, as Alice said, I think the most confusing thing is the lawyer acting like he shouldn't have any of this stuff at all. That is not true. As Alice said, discovery, when you file a subpoena and you seek information from someone you're involved in a lawsuit, they have to turn it over if it's relevant. If it's overbroad or it's burdensome or it's irrelevant, you're in a traffic accident and they ask for all your financial documents and all your emails and all your texts you've ever sent. That's an overbroad subpoena asking for irrelevant information. You could move to have that quashed or limited, and a court is certainly going to grant that. But in this case, the whole question was, when Alex Jones was saying all these things, did he really believe them? Did he know how much harm he was doing? So any text message or emails that he's sending that involve what he's saying are going to be relevant and are going to be discoverable. They should have been turned over. So to the extent that the lawyer is saying it was an accident, it wasn't an accident. The lawyers were doing what they were supposed to do. It may have been an accident that they sent all the information. And that's where it gets a little weird because, number one, the lawyers would have known that they sent this information to the plaintiff because they had to turn it over. So they knew they sent it. Number two, given that fact, why didn't they prepare their client to get asked these questions on the stand? Number three, once they were informed by the plaintiff, which they were, that they had turned over the entire phone, why didn't they seek to officially, what sometimes is called, claw it back and assert privilege over it? Because imagine how this went down. Alex Jones has his phone. He turns it over to his attorney. His attorney now has an attorney-client privilege with him over this information, and they receive the subpoena, and anything that is responsive to the subpoena will be turned over. But the rest of it should remain privileged between Alex Jones and his attorney. It's irrelevant. It shouldn't be turned over. It's not responsive. All sorts of reasons. Once they turned it over, they should have sent a formal letter to the plaintiff saying, we're asserting privilege over everything that's not responsive to the subpoena. Please return that to us. And I think the plaintiff's attorney, I mean, I don't know if they would have fought that or not, but what they should do in that situation is send it back. It doesn't seem like that happened. According to the plaintiff's attorney, they made some sort of vague, well, don't use anything that we sent you that's not responsive. And that's not that's not good enough.
That's a really important point Brett just made. It is not the duty of the receiving party to send back anything. They did their part when they alerted them, but as long as there's no formal request for the information back and essentially to strike it from whatever discovery there is, it's free game. It's in their possession. They absolutely can. And by the way, in discovery, a lot of times you turn over things that are not exactly relevant because it's covered within your search or you don't want to be accused of not complying with the subpoena. So you're like, okay, fine, good luck going through these thousands of documents and finding what's relevant. So that happens a lot. And just saying, well, don't use it is not good enough. And anyways, they used what was relevant. So that's kind of beside the point because what they used was relevant. And in fact, if they got this information just 12 days earlier, as the attorney seemed to indicate in the question, it probably means the discovery was late coming. And it may have been that, I mean, good faith. Let's just say best case scenario, that was supposed to be turned over in discovery. And somehow this piece of information was left out by accident. And in the course of trial prep, Alex Jones' attorney realized they hadn't turned over discoverable information. And instead of being sanctioned by the court or declaring a mistrial or delaying trial, they quickly turned it over. On the other end of the spectrum, some may accuse them of not turning it over because they were trying to hide information until the last possible moment. And the reason they did turn it over is they don't want to lose their bar licenses. They don't want to actually be in violation of a subpoena. They just don't want the plaintiffs to have more time with the information because maybe it is a ton of information. Guess what? Maybe they meant to send over the entire phone because have you ever looked at an entire phone dump? It's a ton of information and it's a lot of information that's not relevant. That may have been the point. So it took the plaintiffs a lot of time to go through the contents of a phone to find what was relevant. That may have been their tactic, and which is maybe why they didn't claw back anything, because in clawing back things, they would have highlighted what was relevant for the purposes of trial.
And I'm so glad you made that point because I would never accuse a fellow member of the bar of doing anything.
I'm not accusing anyone. I'm saying the other side of the spectrum.
But there's a couple things, and you've said it perfectly, so I'm just going to repeat you.
Repeat away.
Someone can complain about that later. But they'll all think it's an original thought for me, right? Isn't that what psychologists say? Is if a man repeats something a woman says, everybody thinks it's an original thought.
I love your
A woman
self-awareness.
repeats something a man says,
Yeah,
everybody notices. Anyways.
I think I told you that fact, so
But I'm going
thank
to do
you.
it anyway. Yeah, you did. You did. So, no, two things. Imagine you have one document and it's really, really damning to you. And it's the only thing relevant and responsive to the subpoena, but you have 10 million other irrelevant things. Maybe you would say to the other side, we just want to be totally fulsome with you guys. We're not going to hold anything back. Here's 10 million pieces of paper. Good luck finding that one document that's important to you. And your hope is, particularly when you don't do it until 12 days before they're going to use it, you didn't give it to them 6 months before, your hope might be they never find the document. Best way to hide a damning piece of evidence is to just pile other evidence around it. And then you can always say, we were just being responsive. We just gave them everything we had. We didn't want to hold anything back, right? And then, as Alice said, let's imagine it was a mistake and they didn't mean to send the whole phone. Well, they really are kind of in a rock and a hard place at that point, because if they claw back things, then they are basically saying, oh, those are the things you really want to use. Those things we didn't claw back. You really need to read those because those are bad, right? So it's possible that this was a sandbag attempt gone wrong. It's possible they just didn't want to call it back because once they'd given it to them, you don't want to highlight things. One thing that is hilarious that they attempted to do was they sought a mistrial based on their own stupidity, basically.
This is the ridiculous part. Of everything that's happened, I know everyone focused on the fact that this was, evidence that shouldn't have been turned over. That's incorrect, by the way. I hope you all know that now. But the most ridiculous of this whole saga is their motion for a mistrial based on their own turning over of evidence.
And the judge basically just rolled her eyes at them when they did it. I mean, and just said something like, yeah, this is the 17th time you've asked for a mistrial. We're not having a mistrial based on you turning over too much information. And they tried to say, well, we told them not to use it or whatever.
But it was relevant. What they used was relevant. I think the more egregious part, and this part I do not understand. I don't know what is the motivation or the reason for this evidence coming in late. But what they should have done when they were alerted that they turned over the entire contents of their client's phone was to prepare their client, because maybe Alex Jones is a great actor, but I think he was truly thrown off. And because of that, he was impeached repeatedly. And it looked so bad for him to say, I have 0 emails. And then email after email came out. They should have prepared their client. And I do not know why they did not do that.
That is so true. And I have no idea how much he was paying them, but it was clearly too much. And that is so basic is the thing, to not have him ready for the questions about those emails and text. And you're right. I mean, maybe he is a great actor, but he looked utterly stunned by those questions. And we talk about this all the time. You don't have Perry Mason moments in real life. They are so rare because everything about trials, criminal and civil, is so regimented. It's slow and it's boring and we're exchanging discovery and these are the things that are relevant and aren't relevant. I mean, there's no way that any lawyer, a first-year lawyer, first-year law student wouldn't know that he was going to be asked about those questions and that the most important thing is to prepare him so he's ready for it. And that didn't happen. It didn't happen. Or if it did happen, it was the worst preparation ever because he was not prepared. And like I said, it'll be interesting to see what happens. No appeal is going to work here. This was not a violation of anything. This was foolishness on the part of his lawyers, or maybe an intentional strategy that backfired. Either way, it will be interesting to see whether he files a malpractice suit against them. Malpractice is hard to prove. You do have to show that the mistake was prejudicial to you, and that it's not quite a but-for thing, but it's pretty close. Like, but for this mistake by the attorney, the case would have gone differently. It's a high bar, but this was pretty bad. This was pretty bad. So it'll be interesting to see what happens in the end. Well, Alice, I think we've covered a lot today.
The double fisting got you through a lot of us rambling, but I hope you guys enjoyed it because we had a lot of fun talking. We were just shooting the breeze, talking about these two issues because you guys had written us about it. And we're like, wait a second, we should record this and actually talk about it because I think this is what you all wanted to hear. So thank you for your questions. If this is not what you wanted to hear, then please speak up. Let us know what you do want to hear. And thank you for being such good listeners of this podcast and also of our our other podcast, the Prosecutors Podcast. And please keep leaving your reviews. That's how other people hear about us, is when you leave your reviews and leave your comments so that others can know what we do, what we talk about. And find us on all the social media platforms, all of them. I don't know. We can be found at Prosecutors Pod on Twitter, Facebook, and Instagram. And Brett, before we sign off, do you have anything to add?
Well, I do just want to say you guys are the best ambassadors for this show. And I know some of you don't like leaving reviews and all that stuff. The most important thing you can do is tell your friends. Tell your friends you listen to the show. Get us a new listener. And if that person gets a new listener and then they get a new listener, it's, it just spreads like wildfire. So that's the one thing we would ask of you guys is if you like the show, tell somebody and help us keep growing it, because we do love to talk about this stuff. And we've had so many people tell us things like, there was a question at the dinner table about the law and I was able to answer it because of you guys. And that's awesome. And that's what we want. So keep spreading the word so more people can listen to the show.
Well, until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutors Legal Briefs. So were you just popping open a bubble water, or were you popping open an alcohol?
A bubbly water.
Okay.
It's
I didn't know what kind of a night it was going to be.
Blueberry pomegranate bubbly.
Ooh. When they had the two flavors together, I'm like, way to be bold.
Yes, it's like the height of civilization is the blueberry pomegranate. I love flavor, man.
I love flavor too. I'm just saying I can't really taste anything else.
Take me to Flavor Town.
Flavor Town.